a section-by-section walkthrough of California Form FL-311, the attachment that spells out a requested legal custody, physical custody, and parenting time schedule, including how it attaches to FL-300 or FL-100 and common mistakes to avoid. What is Form FL-311? Form FL-311 is the California Judicial Council form titled Child Custody and Visitation, Parenting Time Application Attachment. It exists to translate a general request for custody into a concrete, workable arrangement, who makes major decisions for the children, where the children live, and exactly when each parent has parenting time. It is always attached to another form. FL-311 does not open a case or a request on its own. It supports a broader filing by adding the custody and parenting time detail that form doesn't have room for. Why the court needs a separate attachment. A request for order or a petition tells the court that custody is at issue. FL-311 tells the court, in detail, what arrangement is being proposed. Courts generally prefer and often require a specific proposed schedule rather than a general request, because a specific schedule is something a judge can actually review, adjust, and sign as an order. When you use FL-311, FL-311 is filed together with whichever form is asking the court to address custody in your case, FL-300, request for order, and FL-100, petition. If your case does not raise a custody or parenting time issue, you do not need FL-311 at all. For background on the form, FL-311 most commonly attaches to See how to fill out form FL-300. Filing FL-311 without attaching it to the correct underlying form, FL-300 or FL-100, is one of the most common reasons a custody request gets flagged as incomplete. FL-311 cannot stand alone. How California decides custody. California courts decide all custody and parenting time matters based on the best interest of the child. There is no formula that automatically favors one parent, and requesting a particular arrangement on FL-311 does not promise the court generally will order it exactly as written. What does help is clarity. A parenting time schedule that names actual days, times, and exchange locations gives a judge something concrete to evaluate and, if appropriate, adopt directly as the court's order. A vague request forces the court to fill in details on its own, and that often produces an outcome neither parent anticipated. For a broader look at the legal standards behind these decisions, see California Child Custody Laws Explained. Section-by-section walkthrough of FL-311. Here's what the form actually asks you to specify. Legal custody. This section addresses who has the right to make major decisions about the children's health, education, and welfare. You'll request one of the following: joint legal custody. Both parents share decision-making authority. Sole legal custody to one parent. Only that parent makes major decisions. Joint legal custody is a common starting request and does not require parents to agree on every decision. It means neither parent is entitled to decide unilaterally without consulting the other. Physical custody. This section addresses where the children actually live day to day. You'll request one of the following: joint physical custody. The children spend significant time living with each parent. Primary physical custody to one parent, with parenting time for the other parent. Legal and physical custody are requested separately, so it's entirely possible to ask for joint legal custody paired with primary physical custody to one parent, along with a defined parenting time schedule for the other. Parenting time or visitation schedule. This is the heart of the form. Here you lay out the actual schedule you're proposing, including weekday schedule, which parent has the children on which weekdays, and pickup and drop-off times. Weekend schedule, typically alternating weekends with start and end times. Holiday schedule, how major holidays and school breaks are divided or alternated year to year. Vacation time, how each parent's vacation time with the children is scheduled and how much notice is required. Exchange details, where and how the children are picked up and dropped off between parents. Pro tip: write your proposed schedule as if a judge who has never met your family will read it cold. Special situations, supervision, and safety. If there is a safety concern, this section lets you request supervised visitation, meaning a parent's time with the children is monitored by a professional or a supervised visitation facility, or, in serious cases, no visitation at all. See the next section for more detail on how these requests work. Special situations, supervised or no visitation. Not every case involves a straightforward schedule between two safe, cooperative parents. FL-311 accounts for situations where safety is a genuine concern. Supervised visitation, a parent has time with the children, but only in the presence of a neutral third party, either a professional monitor or a supervised visitation facility, rather than unsupervised. No visitation, requested only in serious circumstances where the requesting parent believes any contact would put the children at risk. Requests for supervised or no visitation are taken seriously by the court and generally require you to explain the specific safety concern. These are not requests to make lightly or use as leverage in an otherwise ordinary custody dispute. Common mistakes to avoid: writing a vague or open-ended schedule, such as reasonable visitation, instead of specific days, times, and exchange locations. Filing FL-311 without attaching it to the correct underlying form, FL-300 or FL-100. Confusing FL-311, your request, with FL-341, the form used for the court's final custody order. Leaving holidays or school vacations unaddressed, which often leads to disputes later. Requesting supervised or no visitation without clearly explaining the underlying safety concern. Proposing a schedule that doesn't account for realistic logistics, like each parent's actual work schedule or distance between homes. What happens after you file FL-311? FL-311 becomes part of the court's record for your custody request once it's filed and served, along with the underlying FL-300 or FL-100. From there, the other parent has an opportunity to respond, agreeing with, modifying, or contesting the proposed schedule. If the parents don't agree, many California counties require mediation through family court services before a judge hears the matter. At a hearing, if one is needed, the judge considers both parents' proposals under the best interest standard. Once the court decides, the actual order is issued using Form FL-341, Custody Order Attachment, which may adopt your proposed schedule, the other parents, or a modified version of either. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your FL-311 for you. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.